I've been practicing law for 22 years. I've defended corporate executives who cooked their books so creatively it looked like modern art. I've argued environmental cases in front of judges who didn't want to hear a single word I had to say. I once represented a man who was absolutely, undeniably, 100% guilty of exactly what he was charged with, and I still got him a reduced sentence, because that's what lawyers do. We find the angle, we find the thread, and we pull until something comes loose. I have never, in 22 years, been surprised by anything a client said when they walked through my door. And then, on a Tuesday morning in March of 2187, Queen Sarathis Vale Mondra of the Mondran Sovereignty walked through my door, sat down across from me, and said, "I require your services immediately. My throne is being stolen, and you are the only species in the known galaxy who can help me get it back." She wasn't speaking English technically. She had a translation collar, thin, pale gold, fitted against the underside of what I can only call her jaw, though that word doesn't quite cover what Mondrans have instead of jaws. It converted her speech in real time, and the English that came out was perfect. Slightly formal, a little clipped, but the meaning was crystal clear. I want you to understand what it looked like, sitting across a conference table from a Mondran queen. Mondrans are tall, about 8 feet when they're fully extended, which they rarely are in mixed species company, because they've learned that it makes humans uncomfortable. Queen Sarathis was sitting, which for her species means something like a controlled folding down of the lower body, and even sitting she was nearly my height standing up. Her skin, and I'm using that word loosely, because it's more of a membrane over crystal situation, had this deep blue-violet tone that shifted when she moved, like oil on water but slower, more intentional. Her eyes were amber, 4 of them arranged in a slight arc, and they all tracked me at once, which I had to actively tell myself not to find disturbing. She was wearing what I later learned was her formal diplomatic dress, a structured garment of woven light fiber that caught the fluorescent office lighting and turned it into something that looked like sunset. I was wearing a charcoal blazer with a coffee stain on the left lapel that I hadn't noticed until that exact moment. My paralegal, Jonah, was standing in the doorway behind her with the expression of a man who has seen something that has fundamentally altered his understanding of the universe and hasn't yet processed what that means for his Tuesday. "Close the door, Jonah," I said. He closed the door. I later found out he went directly to the kitchen, made himself a cup of tea, and sat very quietly for about 15 minutes. I looked at Queen Sarathis Vale Mondra. "Okay," I said, "start from the beginning." She had come to Earth because Earth was the only place she could come. Let me explain the political situation, because without understanding it, none of what happened next makes any sense. The Mondran Sovereignty is one of the oldest political entities in the Orion Arm. They were building star-spanning civilizations, while our ancestors were figuring out that fire was useful. They have diplomatic relationships with 47 recognized galactic species, trade agreements that predate human written language, and a legal tradition that goes back over 12,000 years by our calendar. And in all of that time, across all of that history, they had never once had to deal with a succession dispute. The Mondran throne passes through a mechanism called the proof of continuance. I won't pretend I understood it the first time it was explained to me, or the second, or honestly the 5th. But at its core, it works like this. When a Mondran ruler dies or steps aside, their successor is identified not by bloodline alone, but by a biological and psychic resonance between the heir and what the Mondrans call the Sovereignty Stone, a physical object, roughly the size and shape of a large grapefruit, that has been in the royal family for as long as their records go back. The stone doesn't choose the heir. The heir's genetic and neurological pattern has to match certain parameters encoded in the stone. It's part DNA test, part something that human science still doesn't fully understand, and part legal proof under Mondran law. Queen Sarathis was 53 years into her reign. She was healthy. She had no plans to step aside. But her younger sister, a woman named Vareth Keln Mondra, had gone to the Galactic Tribunal 2 months earlier and filed a challenge. Vareth claimed that the original proof of continuance that had placed Sarathis on the throne was fraudulent, that the records had been altered, that the stone's readings had been manipulated, and that Sarathis was, in effect, a usurper who had been sitting on a stolen throne for over half a century. The Galactic Tribunal had accepted the case, which meant that until the case was decided, Queen Sarathis's authority was in what the tribunal called provisional suspension. She could not issue binding royal decrees. She could not command the royal fleet. She could not represent the sovereignty in treaty negotiations. She was, legally speaking, a queen without a crown, still sitting in her palace, still wearing her formal robes, but stripped of every practical power she had ever held. And her sister, the one who had brought the case, was doing exactly what you do when you've put your rival in legal limbo. She was moving pieces, making promises, positioning herself. So why Earth, why me? Because the Galactic Tribunal, for all its 12,000-year history of Mondran legal tradition, had done something 6 years ago that nobody at the time had thought would matter much. They had expanded their jurisdiction to include member species of the Coalition of Younger Worlds, a diplomatic bloc that included, among others, humanity. And in doing so, they had agreed to accept legal representation from any registered attorney of any member species. Most of the older galactic species had looked at that clause and thought nothing of it. Human attorneys, sure, fine, whatever. Humanity had been in the galaxy for about 60 years at that point. They had 1 colony, 2 space stations, a handful of diplomatic outposts, and a reputation for being unexpectedly resilient and slightly exhausting to negotiate with. Nobody at the tribunal had ever actually had a human lawyer stand up in their courtroom. Queen Sarathis had done the research, and what she had found was this: human legal tradition, particularly the adversarial common law tradition developed in the Anglo-American legal system, operated on a fundamentally different logic than anything in the Galactic Tribunal's experience. The tribunal used an inquisitorial model. Judges investigated facts, asked questions, made rulings. There was no real concept of cross-examination, no tradition of aggressive evidence challenging, no precedent for what, in human law, we call impeaching a witness. The Queen needed someone who would fight. The tribunal, by its own rules, couldn't stop her from having one. "I have reviewed the documentation of your career," she said to me, across that conference table, with her 4 amber eyes all watching me at once. "You have a pattern. You take cases that appear to be decided and you find the places where they are not. You look for what others have assumed to be solid and you demonstrate that it is not. This is what I need." I looked at her for a long moment. "What's the timeline?" I asked. "The preliminary hearing is in 9 days." 9 days, I repeated. "Yes." "At the Galactic Tribunal." "Yes." "Which is not on Earth." "No. It is at the tribunal seat, in the V Horus system. Travel time from Earth is approximately 31 hours via Mondran diplomatic vessel." I thought about my current caseload. I thought about the Hartman Singh merger case that was supposed to go to arbitration next month. I thought about the 3 other clients whose files were sitting in my office waiting for attention they deserved. And then I thought about the fact that a queen, an actual alien queen, from a civilization that had been around when my ancestors were painting on cave walls, had come to my door on a Tuesday morning and told me I was the only one who could help her. "I'm going to need complete access to all documentation," I said. "Every record of the original proof of continuance. Every piece of evidence your sister has filed. Every prior ruling by any tribunal judge who might be assigned to this case. Everything." "Of course. And I need to understand Mondran law well enough to know what I'm working with. Not just the legal code, the philosophy behind it, why things are the way they are. I have a legal scholar on my staff who can assist. Good. I picked up my pen, an actual physical pen, one of my small vanities in a world that had largely gone digital. One more thing. If I take this case, I run it my way. I will consult you. I will keep you informed. But in that courtroom, the strategy is mine. I need you to trust that even when you don't fully understand what I'm doing. Queen Sarathis looked at me for a long moment. When a Mondran goes still like that, all four eyes focused and unblinking, it's not threatening exactly, but it is the most attentive thing I have ever experienced. Like being studied by someone who is very, very good at studying things. Agreed, she said. Then I'll take your case. She tilted her head, a gesture I later learned was the Mondran equivalent of a nod. I was told that human lawyers charge a fee for their services. We do. Name it. First, let's see the evidence, then we'll talk about fees. Archival interlude, notes from the desk of Jonah, Priyakellman. Paralegal, Cross and Associates Legal Services. Personal Journal, March 11, 2187. I'm going to write this down, because if I don't write it down, I'm going to convince myself it didn't happen. Alina took the case. Of course she took the case. Alina takes every case that looks impossible and somehow makes it look like she planned it that way from the beginning. But this time the client is a queen. Not like a metaphorical queen. Not a nickname. An actual sitting monarch of an alien civilization. She arrived this morning in a vehicle that I can only describe as a diplomatic shuttle that had no business landing in the parking structure next to the Hartman building, and she walked through our front door and asked the receptionist, poor Sandra, who has been working at this firm for 11 years and has survived a lot, asked Sandra if Alina Cross was available. Sandra came and got me. Good instinct, Sandra. By the time I got to the lobby, Queen Sarathis was standing there, all 8 feet of her, looking around at our very normal human law office with the specific expression of someone who is politely not commenting on how small everything is. I showed her to the conference room. I texted Alina. Alina appeared in approximately 4 minutes, which is fast for Alina when she's in the middle of something, so she must have felt the urgency. Alina walked in, introduced herself, offered her hand. And you know what Queen Sarathis did? She shook it. Full hand-to-appendage contact, no hesitation. Apparently the Mondrans know about human handshakes. They researched us before they came. That's the part that gets me. She researched us. She chose us. She came here all the way to a law office in New Chicago, on Earth, which is pretty much the newest, least impressive address in the galaxy, because she thought we were her best chance. Alina always says the best clients are the desperate ones. They trust you. They let you work. I've got a feeling this is going to be the most interesting case I've ever seen from the coffee-making end of things. My name is Calum Vreth Ondas. I have been a scholar of Mondran legal tradition for 47 years. I was assigned to assist Attorney Cross from the moment Her Majesty retained human counsel, and I want to state clearly for this record that I arrived at that assignment with what I will politely call significant reservations. I had studied human civilization. I had read their legal history. I knew of their adversarial system, their courts, their tradition of argument as a tool of truth-finding. Intellectually, I understood why Her Majesty had made this choice. But I had never actually worked with a human lawyer. Attorney Cross arrived for our first working session 7 hours after Her Majesty retained her. It was 3 in the morning, New Chicago time, which I mention only because she had clearly not slept, and yet she arrived with a case file she had already begun building, a list of 47 specific questions about Mondran succession law, and what she called a preliminary evidentiary framework that she had sketched out on the 31-minute shuttle to the Mondran diplomatic compound. My reservations did not disappear immediately, but they began to shift. She asked me to explain the proof of continuance as if she had never heard of it. I started with the basics, the genetic resonance mechanism, the stone's encoded parameters, the historical record of its use. She listened without interrupting, which I had been told human lawyers did not do. She took notes. When I finished, she asked one question. What happens if the parameters in the stone change over time? I paused. They do not change. The stone is a fixed record. Are you certain of that? Has anyone independently verified that claim in recent history, or is it an assumption built into the legal framework? I opened my mouth. I closed it. In 47 years of legal scholarship, I had never been asked that question. Because the stone's immutability was a foundational premise of Mondrian succession law, it was not a claim that required verification. It was the ground on which everything else stood. I would need to review the archival literature, I said. Please do, she said, as soon as possible. That was the first moment I understood what kind of lawyer I was working with. Witness statement, ELEANORMABRY Cross continued. The thing about walking into an unfamiliar legal system is that you have to choose very quickly between two approaches. You can spend your time trying to become an expert in that system, learn its rules, master its procedures, become fluent in its assumptions. This is the thorough approach, and it's exactly wrong because you'll never be as fluent as someone who grew up inside the system, and you'll lose the one advantage you actually have, which is the outsider's eye, the fresh perspective, the ability to ask why about things that have stopped being questioned because everyone has assumed they're settled. Or you can do what I did, learn enough to operate, and then use your native legal instincts to find the assumptions nobody's testing. The case against Queen Sarathis, as filed by her sister Varath, rested on 3 pillars. Pillar 1, a set of records from the original proof of continuance, records that Varath's legal team claimed showed irregularities in how the stone's readings were documented at the time of Sarathis' succession. Pillar 2, testimony from a former member of the Mondrian Royal Archive staff, who claimed to have witnessed the alleged manipulation of those records. Pillar 3, a comparative analysis done by a galactic tribunal-appointed scientific expert that claimed to show a measurable discrepancy between the stone's current readings and what the archive documentation said its readings had been at the time of succession 53 years ago. On the surface, this was a solid case. A document trail, a witness, and a scientific opinion. That's the 3-legged stool that holds up most legal cases. But I've been taking apart 3-legged stools for 22 years, and the first question you always ask is, are all 3 legs actually supporting the case, or are they all leaning on each other? If the stone was immutable, if its parameters could not change, then the comparative analysis made sense. A discrepancy would indicate fraud. But if the stone was not necessarily immutable, if its readings could drift or change over time through some mechanism not accounted for in Mondrian legal tradition, then the comparative analysis was not evidence of fraud at all. It was just evidence of change, and the entire case started to shake. Dr. Ondas came back to me 36 hours after our first conversation. He looked, I have to say, like a man who had just discovered that the floor he'd been standing on for 47 years was not actually solid. I reviewed the archival literature, he said. The last independent verification of the stone's immutability was conducted approximately 300 years ago. Since then, the immutability has been assumed as a legal fact and has not been tested. I said nothing. I waited. There is, however, he continued slowly, a school of thought in Mondrian natural philosophy, not legal scholarship, not widely cited in legal contexts, that suggests crystalline resonance matrices of the type the stone is composed of may undergo long-cycle vibrational drift over time periods exceeding 200 years. I put down my pen. How long has the stone been in use? According to records, approximately 12,000 years. And how long is a long cycle vibrational drift in this context? He looked at his notes. The relevant research suggests cycles of between 150 and 400 years. I picked up my pen again. I need the name of the best natural philosopher in the Mondrian sovereignty who specializes in crystalline resonance matrices, I said. That would be Professor Sethais Orvin at the Institute of Mondrian Sciences. Get me a meeting. I have served on the Galactic Tribunal for 61 years. I have presided over disputes between species, trade conflicts, territorial claims, and succession challenges. I have seen every manner of legal argument the galaxy has produced. I had never seen a human attorney before the day Alina Cross entered my courtroom. I want to be honest about my initial impression. She was small, humans are, by galactic standards, quite small. She was young-looking to my eyes, though I understand she was well into the middle period of human adult life. She wore a dark garment that I was told is called a suit, which is apparently standard formal attire for human legal proceedings. She carried a physical case of documents, which is almost entirely obsolete in tribunal practice, and she spent the first 20 minutes of the preliminary hearing studying the room in a way that made me briefly wonder if she was uncomfortable. I later realized she was not uncomfortable, she was mapping. The preliminary hearing proceeded as expected. Varath's legal team, headed by a Mondrian attorney named Velith Karas Andrin, who is one of the most experienced practitioners in Galactic Tribunal history, presented their initial filing and outlined the 3 pillars of their case. Attorney Cross listened to all of it. She made notes. She did not object to anything during the presentation, which was unusual. In my experience, attorneys, particularly those representing a client facing serious claims, tend to contest and qualify aggressively during preliminary hearings, both to protect their client's position and to signal to the other side that they intend to fight. She sat quietly and took notes. At the end of the presentation, when I asked if counsel for the Queen wished to respond, she stood up, thanked me for the opportunity, and said simply that the defense would be prepared to challenge all 3 pillars of the opposing case at the full hearing, and that she anticipated the proceedings would benefit from the testimony of one expert witness not yet entered into the record. Attorney Andrin looked surprised. What expert witness? Professor Sethais Orvin of the Institute of Mondrian Sciences, expert in crystalline resonance matrices. The silence in that courtroom was the kind of silence that has texture. You could feel everyone in that room, and there were 312 accredited observers from 17 species, adjusting something in their understanding of what kind of case this was going to be. Attorney Andrin said, very carefully, "On what grounds does the defense propose to call a natural philosopher in a succession law case?" Attorney Cross said, equally carefully, "On the grounds that the opposing case's 3rd pillar rests on a scientific premise about the sovereignty stone's immutability that has not been independently verified in 300 years, and that the defense intends to demonstrate that this premise may be fundamentally in error. I have been doing this for 61 years. I granted the witness. I was assigned to escort Queen Sarathis to the tribunal seat and to remain on station for the duration of the proceedings. I need to explain something that outsiders sometimes don't understand about Mondrian royal culture. The relationship between a Mondrian ruler and her guard is not simply professional protection. It is a bond of mutual obligation that goes back to the earliest days of the sovereignty. We are not employees. We are not merely soldiers. The guard swears an oath to the sovereign that is second only to the sovereign's own oath to the sovereignty. If the throne falls, the guard falls with it. For the duration of the case, while Her Majesty's authority was in provisional suspension, there was a question, never spoken aloud but present in every room, about what exactly we were protecting. A queen without legal authority is still a person. She still required physical safety. We continued to serve. But the uncertainty was corrosive. You could feel it among the guard. The quiet conversations that stopped when certain officers walked in. The extra formality that people adopt when they are covering anxiety with procedure. And then there was Attorney Cross. She arrived at the tribunal seat having clearly not slept much in the 9 days since she'd taken the case, but moving with the specific energy of someone who is running on purpose rather than fuel. She introduced herself to me. She made a point of learning the names and ranks of every member of the guard present, which no legal representative had ever done before, and then she asked me 3 questions. First, was the original proof of continuance ceremony recorded by audio and visual archive? Second, were any members of the Royal Guard present at that ceremony still living? Third, had any of those members ever been formally interviewed about what they witnessed? I told her, yes, partial recording existed. Yes, 3 guards from that ceremony were still living. No, none of them had been interviewed. She asked for their names and contact information. I gave them to her that same evening. Later, after the case concluded, she told me that the guard testimony became one of the most important pieces of evidence in the entire proceeding. I will come back to this, but I want to put on record that she thought to ask. In all the legal maneuvering and expert testimony and document analysis, she remembered that there were people who had been in that room. People who had seen things with their own eyes. That is, I think, a very human thing to do. Witness statement. Eleanormabry Cross continued. Let me tell you about the day I met Professor Sethis Orvin. The Institute of Mondrian Sciences is located in what I can only describe as a cathedral to knowledge, a vast, interconnected series of towers on the Mondrian homeworld, Mondras Prime, where the architecture is built to maximize the unique atmospheric light that the planet gets in the late morning hours. It hits the crystal panels in the walls and scatters into colors that don't exist in human visual language. I stood in the main atrium for about 30 seconds just experiencing it. Then I went to find my expert witness. Professor Orvin was not what I expected. In my experience, expert witnesses come in 2 types. The ones who are so invested in their own expertise that they resent being pulled into legal proceedings because it feels beneath them, and the ones who love an audience and will say whatever gets them the most attention. The best expert witnesses are the rare third type, people who are genuinely passionate about their field and who understand that explaining complex things to non-experts is itself a valuable skill. Professor Orvin was 87 years old by the Mondrian calendar, which put her at maybe 65 in equivalent human terms. She had 3 of her 4 eyes, the 4th having been injured in a laboratory accident decades ago, and replaced with a mechanical equivalent that she had decorated with a small painted pattern. She moved around her laboratory with the efficient economy of someone who knows exactly where every object in the room is. I explained the case to her, the stone, the comparison analysis, the claim of immutability. She listened. She asked 2 questions. Then she went to her desk, pulled up a research paper, and handed me a data tablet. This was published 42 years ago, she said, by a colleague of mine. He studied crystalline resonance matrices of the exact type that the sovereignty stone is composed of. He found evidence of what he called long-cycle sympathetic drift, a gradual, periodic shift in the matrix's resonance parameters over time spans exceeding 150 years. I looked at the paper. Was it peer-reviewed? Extensively. Was it ever cited in legal scholarship? As far as I know, never. It was published in a natural philosophy journal. Legal scholars would have had no reason to read it. Would it be possible, I asked, to conduct an independent analysis of the sovereignty stone using your methods to determine whether any drift has occurred in the past 53 years? She looked at me with her 3 organic eyes and 1 painted mechanical one. You understand that what you are suggesting would be the first independent scientific examination of the stone in 300 years. I understand that. Her Majesty would have to consent. She will. And the tribunal would have to authorize it. I'll get the authorization. She was quiet for a moment. Then she said something that I have thought about many times since. You are from Earth. I am. You have been in the galaxy for 60 years. Roughly, yes. And you came here, to my laboratory, and asked a question about a 12,000-year-old artifact that none of our own legal scholars thought to ask in the past 300 years. I didn't know what to say to that, so I said, I find it helps to ask questions about things people have assumed are settled. She looked at me for a long moment. Then she made a sound I later learned was the Mondrian equivalent of a quiet laugh. Get me the tribunal authorization, she said. I will run the analysis. Archival document, tribunal proceeding transcript. Cross, Professor Orvin, could you please describe for the tribunal your area of expertise? ORVANE. I am a researcher in crystalline resonance physics, with particular focus on long-cycle behavior in mature resonance matrices. I have been conducting research in this area for 54 years. Cross, in your professional opinion, is a crystalline resonance matrix capable of changing its resonance parameters over time? ORVANE. Yes. This is well documented in natural philosophy literature. Crystalline resonance matrices undergo what is called sympathetic drift, a gradual shift in their resonance parameters caused by interaction with ambient environmental fields over long time periods. This is not a rare or disputed phenomenon. It is a known characteristic of these materials. Cross, and how long does a typical drift cycle take? ORVANE. The research shows that meaningful parameter shifts are measurable over periods exceeding 150 years. Significant shifts of the magnitude that would produce detectable discrepancies in a comparison reading, occur over periods of 200 to 400 years. Cross, you conducted an independent analysis of the sovereignty stone, authorized by this tribunal and consented to by Queen Sarathis. What did you find? ORVANE. I found clear evidence of sympathetic drift in the stone's resonance matrix. The current parameters are measurably different from what I would have expected them to be 53 years ago, based on established drift models. The difference is consistent with natural drift over that time period. Cross, to be specific, the discrepancy that the opposing case's scientific analysis cited as evidence of fraudulent record manipulation. ORVANE is consistent with natural resonance drift, yes. It does not require fraud to explain it. In fact, based on my analysis, a discrepancy of that magnitude over 53 years is almost exactly what the drift models would predict. Cross, thank you, Professor. No further questions. Tribunal record note. Attorney Andrin cross-examined Professor Orvin for approximately 2 hours. Professor Orvin's testimony remained consistent throughout. The cross-examination is on file in full. Key exchanges are excerpted in Appendix C of this document. Tribune VHORESS. Following cross-examination, the tribunal thanks Professor Orvin for her testimony. We will recess until the morning session. Recess 47 minutes. Tribunal Observers Gallery, recorded in crowd audio. Extended murmuring for approximately 3 minutes following recess announcement. I have been practicing law before the Galactic Tribunal for 68 years. I have won cases that appeared impossible. I have developed legal strategies that have been cited in 30 different jurisdictions across the galaxy. I have a reputation, if I may say so without excessive immodesty, for being very difficult to beat. Eleanor Cross beat me. I want to be clear about that because there are versions of this story that make it sound like I was outmatched from the beginning, and that is not accurate. The case as filed was strong. The evidence was solid. The legal arguments were well constructed. Under the normal operation of galactic tribunal proceedings, we should have won. What I failed to account for was the specific way that human adversarial legal tradition interacts with the inquisitorial model of the tribunal. In our system, the tribune investigates and reaches conclusions. The role of legal counsel is to assist the tribune in understanding the case, to present evidence in an organized manner, and to argue the legal interpretation of established facts. It is not, in our tradition, the role of counsel to aggressively challenge the foundational premises of the opposing case. That is the tribune's job. Except Attorney Cross did challenge the foundational premises, aggressively, systematically, and the tribunal rules as modified when humanity joined the coalition allowed her to do it. She did not just attack the evidence. She attacked the assumptions beneath the evidence. She went after the premise that the stone was immutable. She went after the reliability of the archival process that produced the records her client was accused of manipulating. She went after the methodology of our scientific experts' comparison analysis, because, as she demonstrated through Professor Orving, the comparison was based on an unverified assumption about baseline parameters. And then she called the guard witnesses. 3 elderly members of the Mondrian Royal Guard, who had been present at the proof of continuance ceremony 53 years ago. None of them had ever been asked to testify. None of them had been interviewed by any party to the dispute. They described what they had seen at the ceremony. Their descriptions were consistent with the official record. But more importantly, they described the stone's behavior during the resonance reading in physical detail. The specific quality of light it emitted, the duration of the reading, the sounds produced by the ceremony. Attorney Cross then put that physical description next to Professor Orving's analysis of the stone's current parameters, and she argued, convincingly, that the behavior the guards described was consistent with a stone reading that would produce exactly the successor match result that was recorded, and that the current discrepancy was the result of 53 years of drift, not fraud. She built the argument from 3 directions at once: scientific evidence, eyewitness testimony, and a fundamental challenge to the reliability of the opposing case's scientific premise. I did not have a response to that, not because I lacked skill, but because the approach itself was foreign to our tradition. In 68 years, I had never faced an opponent who came in with an entirely different conceptual framework for what legal argument was supposed to do. I want to say, and I want this on the record, that I hold no ill will toward Attorney Cross. She represented her client with complete integrity. She did not fabricate evidence or misrepresent anything. She simply approached the case in a way that the Mondrian legal tradition had never encountered. It was, professionally speaking, extraordinary to witness. The night before the verdict, I couldn't sleep. This is not unusual for me. The night before a verdict in any major case, my brain won't shut off. I go over every argument, every piece of evidence, every moment in the proceedings where I could have done something differently. It's a habit I've never been able to break and have mostly stopped trying to. But that night, sitting in a guest suite in the tribunal seat complex, looking out at the star field through a transparent wall that was the most expensive thing I'd ever been near, I wasn't just going over the arguments. I was thinking about the Queen. I had spent 3 weeks with Sarathis Vale Mondra by that point. I'd spent more time with her in those 3 weeks than most of her own advisors spent with her in a month. We'd worked through documents together in the late hours when her staff had gone to sleep. I'd explained human legal concepts to her, and she'd explained Mondrian political philosophy to me. We'd argued about strategy. She had strong opinions, not all of them right, and she'd accepted corrections with more grace than some human clients I've had. I had come to understand her as a person, a ruler who took the obligations of her position seriously, a woman who had spent 53 years trying to hold a civilization together and was now watching someone try to take it from her with legal papers. She had not complained, not once. She had not expressed self-pity or anger or the particular bitterness of powerful people who feel they're being treated unjustly. She had been precise, disciplined, focused, and occasionally, in moments when we were working late and the formality had softened a little briefly, quietly funny. She had a dry, subtle sense of humor that I never would have expected, and that came out only in small moments. I thought about the guard witnesses, 3 elderly Mondrons who had been young officers at a ceremony half a century ago, who had stood in that room and watched a stone glow and a queen be confirmed, and who had never been asked what they saw. Never, until I came along and thought to ask. There's something that happens when you've been practicing law long enough. You start to see the gaps, the places in every case where the truth is hiding, because nobody thought to look for it there. Not because anyone was hiding it deliberately, but because looking there required someone to ask a question that the established system had never needed to ask. The Mondron legal tradition was 12,000 years old. It was sophisticated, thorough, philosophically deep, and genuinely admirable. And in 12,000 years it had produced a particular shape, a way of seeing legal problems, a set of tools for solving them, a set of assumptions about what needed to be proven and what could be taken as given. And sometimes it takes a newcomer to see what the established tradition has stopped questioning. I wasn't better than Velith Kara's Ondron. I want to be clear about that. He was a brilliant attorney with decades more experience in that specific system than I would ever have. In a straight contest of Mondron legal expertise, he would have demolished me without breaking a sweat. But I brought something he didn't have. I brought 65 years of human legal tradition, a tradition built on the premise that nothing is settled until you test it, that every assumption is a potential weakness, that the job of defense counsel is not just to present an alternative story, but to systematically dismantle the foundations of the opposing one. We call it the adversarial system. The galaxy had never seen it before. I sat by the window for most of that night, and at some point in the early morning hours, I stopped reviewing arguments and just watched the stars. There are more of them visible from the V-Horus system than from Earth, and they're brighter because there's less atmospheric interference. Just stars everywhere, unimaginable distances, and somewhere out there, 57 years ago, a generation of humans had looked up at that sky and said, "We're going out there," and started the long, awkward, complicated process of becoming a galactic species. We were still new. We were still learning. We made mistakes and we had blind spots, and there were plenty of species in that galaxy who thought we were a minor footnote in a story that had been going on for millions of years. But we brought something. I went asleep around 4 in the morning feeling, for the first time in 3 weeks, genuinely confident. Archival document, Tribunal Proceeding Transcript. Tribune VHORESS. This tribunal has completed its deliberation on case GTA 7711, the succession challenge filed by Vareth Keln Mondra against Her Majesty Sarathis Vale Mondra, Queen and Sovereign of the Mondran sovereignty. The case was built upon 3 pillars of evidence and legal argument. Having reviewed all evidence, testimony, and counterargument presented by both parties, the tribunal makes the following findings. Regarding the first pillar, the documentary record discrepancies alleged to indicate manipulation of the original proof of continuance records. The tribunal finds that the alleged discrepancies are insufficient to establish manipulation beyond the standard of reasonable certainty required under Section 7, Clause 4 of the Succession Law Codex. The records, examined in totality, are consistent with the ordinary variation and transcription practices of the period in which they were created. Regarding the second pillar, the testimony of the former archive staff member who claimed to have witnessed record manipulation, the tribunal finds this testimony to be insufficiently corroborated. Under the credibility examination conducted by this tribunal, and in light of the inconsistencies identified through the examination by defense counsel, this testimony cannot be accorded determinative weight. Regarding the third pillar, the scientific comparison analysis claiming to demonstrate that the current stone parameters differ from the parameters recorded at the time of Her Majesty's succession, offered as evidence of fraudulent record modification. The tribunal finds, on the basis of the independent scientific analysis conducted by Professor Sethais Orvain and the established research on crystalline resonance drift, that the discrepancy in question is explained with substantially greater probability by natural resonance drift over the past 53 years than by fraudulent manipulation of the original records. In light of these findings, the tribunal holds that the challenge filed by Vareth Keln Mondra has not met the standard of proof required to invalidate the proof of continuance of Sarathis Vale Mondra. The challenge is dismissed. The provisional suspension of Her Majesty's authority is lifted, effective immediately. Her Majesty's title, authority, and sovereignty are confirmed in full. Tribunal Record Note: following the reading of the verdict, the gallery, approximately 340 observers from 19 species, remained silent for 6 seconds. The subsequent response included sounds consistent with extended, prolonged acknowledgement across multiple species audio registers, lasting approximately 4 minutes. Witness Statement: Commander HETH continued. I have been in the Royal Guard for 31 years. I have seen Her Majesty receive ambassadors, negotiate treaties, navigate political crises that would have shattered a lesser sovereign, and once, this is not widely known, stand down an armed delegation from a rival system using nothing but the force of her presence and about 40 words. I have never seen her do what she did when Tribune V. Horace finished reading the verdict. She was still, completely still in the way Mondrans get when something has struck them very deep, for about 3 seconds, and then she turned to Attorney Cross, who was sitting beside her at the defense table, and she said something. I was positioned too far away to hear it clearly through the post-verdict sound in the gallery, but I saw it, and I saw what Attorney Cross did in response. Attorney Cross, who had been holding herself in the contained, professional posture she'd maintained throughout the proceedings, let out a breath, one breath, like she'd been holding something in for 3 weeks and finally could let it go. Then she said something back to the Queen, short. 2 or 3 words. Then they were both quiet for a moment. Later, after the formal proceedings concluded, I was close enough to hear some of the conversation in the corridor outside the chamber. Her Majesty was speaking to Attorney Cross, and she said, I am quoting as accurately as I can, you did not simply win a case. You demonstrated something about your species. I want you to know that I will not forget this, and neither will the sovereignty. Attorney Cross said, I represented a client, that's what lawyers do. Her Majesty said, no, other lawyers represent clients. You came into a system you had never seen from a species that has been in the galaxy for 60 years, and you found what no one else had thought to look for. That is not what all lawyers do. That is what you did. Attorney Cross was quiet for a moment. Then she said, Your Majesty, with respect, you came to Earth on a Tuesday morning, walked into my conference room and trusted me. That was the harder part. Her Majesty made a sound I recognized, the quiet Mondran laugh. Perhaps we both took a risk. Perhaps we did, Attorney Cross said, and it worked out. I have been Queen for 53 years. In that time, I have learned that leadership requires knowing your own limitations. The most dangerous mistake a sovereign can make is to believe that the institutions and traditions she inherits are comprehensive, that they cover every situation, that they have wisdom for every problem. Traditions are powerful and they deserve respect, but they also have blind spots. They stop questioning things. They stop looking in certain directions because those directions have been assumed to be empty. I came to Earth because my case required something that my civilization's legal tradition did not possess, not because our tradition is inferior. 12,000 years of legal philosophy is not something you dismiss lightly, but it had never needed to do what I needed done in that courtroom. I need to be honest about what I was asking, because I think the historical record should capture the full weight of it. I was asking Alina Cross to walk into the most important legal proceeding of my reign, potentially of my civilization's history, in a system she had never encountered, representing a client from a species she'd had no professional dealings with, before a tribunal that had never seen her kind of advocacy, against one of the most experienced opposing counsel in the galaxy, in a case that had been called unwinnable by 3 separate Mondran legal experts before she was retained. And she said yes. She asked me 2 questions about jurisdiction and evidence access, asked for a reasonable working framework, and said yes. That is, I have come to understand, a very human thing to do. Humans have been in this galaxy for 60 years. By the standards of galactic civilization, they are children, new, inexperienced, prone to the particular mistakes of species who don't fully understand the complexity of what they've stepped into. I had advisors who cautioned me against going to Earth, who told me that a human attorney could not possibly navigate galactic law well enough to matter, who said that by bringing human counsel into the tribunal, I would signal weakness and desperation. Those advisors were not wrong about most things. They were wrong about one thing. They assumed that the value of legal counsel is expertise within the existing system. They didn't account for what it means to have someone who operates from a completely different premise, someone for whom no assumption is sacred, no tradition is unchallengeable, no question is too basic to ask. Professor Orvin's paper had been published 42 years ago. It was available to any legal scholar in the sovereignty. It sat in the literature, unread by any lawyer in any succession case, because succession lawyers read succession law scholarship, not natural philosophy journals. Alina Cross read it because she did not know, before she read everything, what was and was not relevant. She found it because she refused to accept that the opposing case's scientific pillar was solid without testing it. And she did not accept that because she came from a tradition that says nothing is solid until it's been tested. I want this on the record because I think it matters for how the galaxy understands humanity. You are new. You are young. You don't have 12,000 years of legal tradition or 30,000 years of diplomatic history or the refinements that come from having worked through every variation of every problem over millennia. But you ask questions. You challenge assumptions. You walk into rooms where everyone else has stopped wondering about something and you wonder about it. That is a gift. I hope you never stop doing it. Witness statement. Dr. KALEMVRTHONDAS continued. Following the conclusion of the case, I returned to the Institute and published a paper. The first paper of my career that originated in a question asked by someone else. The title, translated roughly, On the Assumption of Crystalline Immutability in Mondran Succession Law, a Case for Periodic Independent Verification. It has since been adopted as a foundational text in the reform of succession law review procedures in 4 Galactic Tribunal member jurisdictions. It would not exist without Alina Cross asking me, on our second day of working together, whether anyone had actually tested the assumption in question. I think about that sometimes. 47 years of scholarship. I had read the Mondran legal corpus more thoroughly than most people alive. And it took 65 years of human legal tradition, and one human lawyer who didn't know what she was supposed to take for granted, to ask the question that needed asking. This is, I think, why the galaxy needs young species. not because they are better, but because they haven't yet learned what not to question. Witness Statement, ELEANORMABRY Cross Final Section. I got back to New Chicago on a Thursday. Jonah had kept things running while I was gone. The Hartman Singh arbitration had been postponed, which actually worked out fine. There were messages, most of which could wait. Sandra had reorganized the filing system in a way that took me a week to get used to but was objectively better. I sat in my office, in my chair, with the coffee stain on the blazer long since cleaned off, and I wrote up my notes from the case the way I always do, detailed, organized, the kind of notes that might be useful if anything similar ever came up again. I didn't know then how many cases like it would come up in the next decade. I didn't know that my representation of Queen Sarathas would, in a very quiet way, change something about how the galaxy thought about human legal capacity. I didn't know that within 2 years, a dozen other species would reach out to human attorneys, not because we were the best, but because we brought a specific, useful thing to the table that the older traditions had set down without noticing. The adversarial instinct, the question asking, the fundamental refusal to accept that anything is solid until you push on it. What I knew, sitting in my office on that Thursday, was that I had taken an impossible case and found the thread. I had pulled on it, and something had come loose, specifically, 53 years of wrongful legal jeopardy for a queen who had governed her people faithfully and well. That's what lawyers do. My phone rang. It was a new client, completely unrelated to anything galactic. A small business dispute, corporate malfeasance, the kind of case I'd handled 100 times. "Tell me everything," I said. "Start from the beginning." And we were back to work. The case of Varath Keln Mondra versus Sarathas Vale Mondra is cited in the following subsequent proceedings: administrative reviews and legal reforms. Amendment to Galactic Tribunal Evidence Standards, Article 12, requires independent scientific verification of material physical premises in cases involving physical evidence of over 200 years of age. Adopted GSD 7712.08. Coalition of Younger World's Legal Integration Framework formally recognizes the adversarial legal tradition as a valid and distinct mode of counsel under tribunal rules. Adopted GSD 7713.15. Mondran Succession Law Reform Act mandates independent crystalline analysis of the sovereignty stone at intervals not exceeding 50 years. Adopted GSD 7712.22. Ondas Protocol, formal guidance for tribunal proceedings recommending that expert witness testimony from outside the traditional field be considered in cases involving physical evidence with long-term behavioral characteristics. Adopted GSD 7714.01. Final archival note, contributed by Tribune v. Horace, 7th Bench Emeritus. There is a phrase that exists in several human languages. I encountered it while reviewing documentation from the case, and I have thought about it often since. Beginner's mind. It comes from a tradition of philosophy that suggests the most useful approach to any problem is to encounter it without assumptions, as a beginner would, with openness rather than expertise's tendency to see what it expects to see. In 61 years on this bench, I had developed considerable expertise. I had also developed, I think, a considerable number of settled assumptions. Eleanor Cross walked into my courtroom without most of them. She asked questions the tribunal had never been asked. She challenged evidence in ways our procedures were not designed to anticipate, but could not prevent. She found the gap in a 3-pillar case that had been assembled by one of the finest legal minds in the galaxy, and she found it not through superior knowledge of Mondran law, but through the refusal to assume that anything was settled. I am 84 years old. I have seen thousands of cases and hundreds of legal practitioners from dozens of species. In my considered opinion, the most valuable thing Alina Cross demonstrated in case GTA 7711 was not legal skill, though she has considerable legal skill. It was this: the willingness to ask about a 12,000-year tradition, but have you actually checked? That question, asked once in the right place, changed history. I expect humanity will ask it again.